that would be fine.
You got it. All right, let's go.
Thank you.
Mr. Lipsy, if you could move your camera a little bit. Perfect. Now we could see you. We could only see your forehead. Much better.
I use a big
Actually
screen,
looking
but I
forward
had
to
to move to a laptop.
No problem. No problem. Now we could see you.
Thank you very much, Your Honor. Stanford Lipsy, I represent the appellant in this cause, Mr. Lowry. Your Honors, we were before the lower court based upon an award of a request for an award of attorney's fees, not only in the lower court, but also based upon a remand from the appellate court. We conducted a hearing before Judge Tibbles, the Honorable Judge Tibbles, and Judge Tibbles made a ruling that in essence, the appellant failed to present sufficient financial information concerning the parties. But we do take issue with that as to the fact that the information that was presented was the testimony of the appellant himself, who unfortunately is somewhat illiterate, does not read and write, and has no financial information whatsoever. We relied upon his wife for the purposes of his financial information, his current wife, not his ex-wife. His current wife, who also did his tax returns, was able to tell the court what his income was over this period of time, which basically was limited to disability because of his situation, and what his finances were. We also were able to present through the appellee what her finances were from this period of time of the dissolution of marriage in 2004 up to the current, which included her average salary, as she testified before the court, ranged from $65,000 to $85,000 a year. My client was on $20,000 a year disability. The court made a finding that we failed to present sufficient financial information. We filed financial affidavits, both from the appellant and the appellee. We also had financial affidavits from the original divorce proceedings. For my client,
Mr. Lipsy, and let's focus on that. And let me begin by asking, our review, I think you'd agree, it is an abuse of discretion standard. We get to review this. And so the judge, and we have the whole transcript here, and you could see the judges engaging with your client to question, to try to clarify some of the things. When you make reference to financial affidavit, wasn't there was some discrepancies, some of them may be inaccurate. Like one of the things that jumped out, your client lists a $3,000 a month vacation budget, while then listing, $1,700 as his totally monthly income. Then later on, he has some things that just the discrepancy in an affidavit, it circles back to the abuse of discretion. Doesn't the judge, who is a trier of the fact, has all this information in front of him or her, gets to determine whether or not it is appropriate testimony to consider? And if he's looking at a financial affidavit that appears to be inaccurate, isn't he free to reject that?
He can reject any part or accept any part of it that he wishes, is my understanding of the law. As with anyone's testimony, that the court has the discretion to either accept or reject the testimony. As I indicated, my client is illiterate. He does not understand finances, and what he put in that financial affidavit, there was two different financial affidavits, and we tried to correct it on the second financial affidavit with the assistance of his wife. He relied upon himself, I believe, as he did the first financial affidavit, which in all candor was an aberration. And that is why I was left at the trial level with relying solely upon the wife more so than him, because as it shows, his financials in his income was limited to $1,700 of disability, a total of $20,000 a year. He knew that's what he paid.
So let's talk about that, Ms. Ricci. Let's explore that. So I know your client testified and the judge was asking, what did you make in the year 2008? He didn't remember. What did you make in the year 2009? I don't know. What did you make? And he went through all of that. Then when his current wife, didn't the judge also go through, what did your husband make in such and such a year? I don't know. What did your husband make in such and such a year? I don't know. What did your husband make? So this is my question to you, is that the judge is really in the best position. He was there. He heard all of that testimony, and he has to have some sort of basis to make a determination. In order to grant fees, this is something that has to be based on, you have to show, your client has to prove that he's entitled to that. And the judge, with his questioning and his engagement to try to find out more information, there was no evidence presented to him that he could come to the conclusion that your client would be entitled to it. And so, with it being an abuse of discretion standard, I want you to tell us, why should we, and Judge Valenti used this example of the last oral argument, that any circuit judge in the state of Florida would never have done what this judge has done. Abuse of discretion is very, very high standard. Why should we, with this high standard, overturn the judge's decision, given the facts and given this record?
Well, Your Honor, as the court notes, and as Judge Tibbles denied, not over counsel's objection, but he denied the information that came from Social Security that we were trying to prove, because this went back to 2007, 2008. And with that, Mr. Townsend did not object to that information. He and his client actually provided that same information in order to have and to present to the court what the parties actually made as income and what their financial circumstances were. I believe, and please, my recollection is that the current wife, did not testify that she did not know what his income was, but knew that he was on disability for all those years and that his income was limited solely to the disability. And so therefore, I believe it was, and Mr. Townsend, and we tried to get financial information. Mr. Townsend objected to it strenuously. He, in fact, didn't want to even give a financial affidavit, but for the judge's insistence that he did a current financial affidavit. So we were limited by the judge himself. I think that the IRS information is very germane and was germane, and the court basically rejected it. But with that, I mean, when you go back 10 years, you're going back 13 years. It's very difficult for anybody to have an actual recollection of what their income was 13 years ago. And that is one of the reasons that we sought to use and attempted to get into evidence the Social Security information, because that is the best evidence as to what the parties were actually earning. We also showed, and I believe my client did testify, that he was on disability, as did his ex-wife, and that income, but for, I believe it was 2020, when he moved from disability to Social Security. So from 2020, but the majority of the application of where we were was from 2007 to 2019. And that in looking at the Rosen case, as well as this case, the cases, it's the application that the court needs to look at, is that each party has adequate representation based upon their ability to pay. And a difference of the income is very substantial in this case, that her income never went below $60,000 a year, and his, but for 2020, 2021, was limited solely to disability, which was approximately $20,000 a year. I don't know if that answered your question.
It has. Thank you.
But thank you. But moving forward, if the judge, and I look back at some of the cases, and there is a necessity for the court to make a finding of need and ability to pay. And I know that the appellate court, when they referred the attorney's fees back to the lower court for finding of the appellate fees, basically said, if you do not consider the merits of the appeal, and I understand that. So, I mean, what we're limited to, in essence, is what is the true financial condition of the parties? And that financial condition was testified to. And I think that it's sufficiently in the record for the purposes of the court being able to make that determination of a need. Rather than make the determination of the need, the court looked at it and said, well, you didn't present any evidence. There's nothing in the record. Well, I beg to differ because in the record is that information. The court accepted, excuse me, the current spouse's testimony and was able to substantiate, I filed the tax return. He doesn't file anything. He didn't know what he made. His check was deposited directly into the account with disability. I mean, you kind of, I guess for lack of a better word, a little bit of leeway needs to be given to somebody who doesn't read, doesn't write, doesn't handle financial circumstances, and relies upon a third party with which to do it. And I don't believe that Judge Tibbles did that. And for that reason, we, in essence, requested the court find, as a matter of law, that the record is sufficient with an explanation that the income is there, the party's finances are there. We met, as I said, with a lot of objection to any evidence. And therefore, that is one of the reasons that I reverted back to, and they provided, and we provided under discovery, the IRS information, because that is the best information. Thank you.
All right, I'll save you the 3 minutes that you asked for. You've got more than that left.
I know. Thank you, Your Honor.
Thank you. Mr. Townsend, your turn.
May it please the court, I represent the appellee, Alma Jean Lowry. I would like to just summarize just exactly what is in the record. The former husband testified that he did not remember any numbers. That testimony pretty much negated anything he had said prior. Secondly, the judge found it to be extraordinary that a pinch hitter was being offered to give testimony as to the income, but nevertheless, it was proffered, and the fact that there was no objection made is rendered moot by the fact that that testimony is here for the court to review. And I would suggest that once we review it, I think the court's concerned about it being having probative value was justified. She testified that she did not know she had no recollection of his income prior to 2012. And as to 2013 through 2020, her testimony was all by memory. She was not given any document.
Can I ask you a question? Mr. Leifstein referred to tax returns that were in evidence. Did the tax returns refer to the gentleman's income? Or that was just a representation of a snapshot in time, and he may have had other income and the judge wasn't bound by that?
My recollection is that the tax returns were not authenticated and did not go into evidence.
So what we really have is a failure of proof?
Yes, sir. A gross failure of proof. And I was attempting to address that. In addition to it, my previous comments, the two affidavits of the former husband that did go into the record were conflicting in two major ways. Number one, actually three major ways. Number one, the first affidavit failed to reflect his employment income. The second one did. Even so, there was an ambiguity in how the income was expressed. So it's not certain whether his income as expressed in the second affidavit was $34,000 or $41,000. And finally, he asserted $89,000 worth of expenses. And you're left to wonder, well, how do you take care of $89,000 worth of expenses if you're only making $34,000 or $41,000? So the affidavits were very problematical. And so I think that the court was not left with the precision that's required in order to make the findings of fact that would otherwise flow from a hearing like this. As far as the complaint that the judge participated in the case, I don't think any of the cases he has cited apply. And most importantly, if he really thought there was a problem, he should have filed a motion to disqualify, but he didn't even bring it up until after finding out what the judge's result was and asserting it in the brief and in this case. And I think that bespeaks of how the former husband really felt about whether or not there was actually any improper behavior on the part of the judge. Thank you.
All right, Mr. Letsey, you wanted 3 minutes, but you've got a few more if you need them.
Thank you, Your Honor. I mean, it was not an issue of the disqualification of the judge. And the issue was that he himself made objections, which I believe the court can or cannot do. And that's how you look at it. The issue is that Mr. Townsend did not make these objections, that the court made the objections on their own. And it would have been necessary normally for counsel to make the objections, not necessarily the court. It's not that she was there pro se and did not know the rules of evidence. But for those reasons, and again, Mr. Townsend refers to $89,000 worth of expenses. Yes, that's $89,000 worth of expenses to the total household, of which the wife participated and had income going into the household. But this is based upon what his income was, not what her income is. But those are the natural expenses. And I believe that, the wife finally got into it. And for those reasons, that's why you end up with $89,000 worth of expenses. But I think we still need to go back to the general proposition of Florida Statute 6116(1), and that is the need and the ability to pay to have adequate representation. As Mr. Townsend noted in his arguments to the lower court, Mrs. Lowry had no obligation to pay any attorney's fees. My client was paying me at the rate of $100 a month, which was a very minimal amount. She had no obligation for payment, and to this date has no obligation of payment to Mr. Townsend. She ended up paying off her attorney's fees in the same or similar way as they were incurred in the initial proceedings to Mr. Townsend for former counsel. But is there a need and is there ability to pay? Yes, there's a substantial discrepancy between the incomes of the parties. And I realize this just does not rely solely upon income. It is the parties' assets. In this case, if you compare what the assets of Mr. Lowry are to the assets in the initial financial affidavit to the current affidavit, it's almost one and the same. The same old cars, the same old information. The only difference is he ended up with a house that's different. As to Mrs. Lowry, the difference in her income is $60,000, $80,000 a year, a 401k that's worth over $400,000, taking money out of it. And my client still sits, and now he was on disability for all that period of time. He definitely had the need, and she had the ability to pay and to contribute. And in fact, in the initial court order, I believe, I don't want to say it was Judge Thomas. I'm at a loss at the moment, but in the initial proceedings, Ms. Lowry was ordered to pay attorney's fees to my client in the initial proceeding. Based upon
You've used up your 3 minutes, but I can give you another up to 2 minutes if you want to keep going.
No, Your Honor.
You've
sorry?
You've used up your 3-minute rebuttal.
Okay.
But
Thank you, Your
technically-
Honor. We certainly appreciate it, and we
Done. All right.
appreciate the concerns of this court and respectfully request that this court find from the record that there is sufficient financial information.
All right. Thank you, gentlemen. Appreciate the argument. We're going
Thank
to
you,
move
Your
on to
Honor.
the
Have a
third
wonderful
case.
day.
Thank you. You too. Heather Lakes versus MTGLQ Investors is next in the queue.